Welcome to XYPN Radio, where your host Alan Moore brings you into a community of fee-only financial planners who want to profitably and successfully serve Gen X and Gen Y clients. If you're ready to get the knowledge you need from leaders in your field, learn from forward-thinking advisors, and take action on your own goals, XYPN Radio is the show for you. Here's your host.
Hello, and welcome to this episode of XYPN Radio. I am your host, Alan Moore, and thank you so much for joining me today. Today's episode, the title may bore you a little bit, talking about the Department of Labor's recent fiduciary rulings, but this is huge, and this is going to be really important for your career. So I brought on Michael Kitces, who typically co-hosts a lot of these episodes, but today I brought him on to basically interview him because, in the beginning of the episode, you'll hear me admit that I'm fairly ignorant of some of the changes that the Department of Labor rules were rolling out, and it was not until I started to read his 7,000 plus word blog post summary on the Kitces.com website that I realized just how big of an impact some of these rulings are going to have. And so we basically walked through kind of a history of where the broker-dealers and RIAs came from and why these rules even needed to come into existence, just to kind of give some clarity around kind of how we ended up here, and to actually hear, both of us say that in many ways this is the broker-dealer's fault. They brought this on themselves. So this entire episode is just talking about the various things that are important in the best interest contracts and the exemptions and all of these various things that are going to affect you. And we close out with the question of, how does this affect me as a fee-only advisor, and what can I do to prepare for it? So you're going to want to listen to this one to the end. I know it's a bit of a longer episode, but it is so important, because in 1 year, basically from when this episode goes live, just under a year, you're going to have to know this stuff. You're not going to be able to claim ignorance. So definitely hang out to the end. And I know you're going to have questions, because I have a million questions about this. And as we say in the episode, there's a lot of clarification to still come. So be sure you join our VIP community at xyplanningnetwork.com/VIP, where you will be able to interact with Kitces and ask him some questions. And as always, you can access the show notes and additional resources at xyplanningnetwork.com/44. All right, without further ado, here's my interview with Mr. Kitces. Hello, Michael. Welcome to the show.
Hello, Alan. It's good to be here.
I love doing this intro because, as most listeners know, you and I most of the time co-host episodes, but today is going to be a little bit different. We're going to go back to old interview format because today we are talking about the extremely exciting, just absolutely riveting topic of the Department of Labor's fiduciary rules.
You imply it's not riveting, as though I didn't just spend like 12 hours of my life over the past couple of days reading 1,000 pages of regulatory documents.
Well, and this is why we love you, is because you are riveted by these things, and we're not. We're just affected by them. So now we get to talk about what you learned in your 12 hours of reading.
To be fair, I guess in defense of my own street cred, like, I will admit there were definitely boring parts of the 1,000 pages. Just so we're clear, like, I don't find it that riveting either. I'm just a glutton for punishment that feels compelled to read all the way through the whole darn thing.
I know. I remember one time when I was giving a presentation at an advisor conference around advisor technology. I was like, well, not only am I a financial planner, I'm a financial planner nerd that loves technology. Like, I'm never going to get invited to a party ever again.
You'll just have to make your own parties where you go, Alan.
I just have to go hang out with people that know about financial planning technology, because there's so many of us. I just pay for my friends. Anyway, so I actually got a couple of media requests around the Department of Labor ruling, which was funny, because the truth was, I was like, I have no idea, because I have personally ignored what has been happening for a couple of reasons. One, because I actually wasn't convinced that anything was going to get done worth paying attention to. And two, I just get so mad about this, that this is even a conversation piece. Because as most listeners probably know by now, we require everyone that joins XY Planning Network has to sign electronically a fiduciary oath. And we put that on the advisor's profile on our Find an Advisor search engine, so that there's no more question of like, oh, are your people fiduciaries or are they not? What's the deal here? Like, everyone's a fiduciary, and they've signed an oath that says they're a fiduciary. And so, like, the fact that the Department of Labor is even having to have this conversation, to me, is just infuriating. So I've honestly kind of stayed out of it. And so I'm coming from a place of flat out ignorance. You might as well be trying to describe brain surgery to me. And so I personally am interested in this topic. You just wrote a 6,000 word summary, because only you can write a summary that's as long as a book.
Well, it was actually 7,400 words.
Of course it was.
If you want to get technical about it.
How long was it before you pared it down?
Oh, God, pushing 10,000. I trimmed about a quarter of it to try to get it to a quote unquote more readable format. For anyone who's read through it and was like, their eyes were watering after the 17th time they hit page down. Like, this really was the trimmed down version. There was a longer one before, which I'll circle back on some of that material in the coming weeks. There's realistically, there's going to be months of people just interpreting some of the fine point provisions of the rule and what's here and kind of figuring out how it's going to apply. There are still a couple of questions out there that are lingering about how certain sections are going to be interpreted. So the Department of Labor has actually been very open already in saying, like, we will be proactive in trying to provide clarifying guidance where people have questions. But there's going to be a lot more still to be said about this over probably the next 3 to 6 months until a lot of the big questions get sorted out. And I think what we'll find is by the time we get to the fall, I think the whole industry collectively will kind of have agreement and consensus of like, all right, here's really what all the fine print means. Here's really what it's going to boil down to at like a very practical grassroots. Like, here are the 5 new things you have to do going forward in your practice because of the new DOL fiduciary rule. And we'll talk about some of that in the discussion here. We have a pretty good sense as to what's coming already, but there's still some interpreting left to be done for what ultimately was a very big ruling. Now, to be fair, it wasn't really 1,000 pages of actual regulatory guidance. The truth for anyone that's followed this issue at all is a number of major broker-dealers and Wall Street firms kind of represented by SIFMA, which is basically the association lobbying advocacy group that speaks on behalf of them, has been pretty vocal in saying that they are considering a legal challenge to this, that they were threatening a legal challenge to the Department of Labor if the Department of Labor, didn't concede enough ground or acted too hastily in their rollout. And realistically, I think the Department of Labor probably conceded enough points to make it very hard for Wall Street and SIFMA to actually succeed in a legal challenge. But what that meant is we basically got like 100 pages of substantive ruling and 900 pages of the Department of Labor explaining every single line item of the provision, every comment that was made about the line items and why they agreed with certain comments and didn't agree with other comments, so that they basically have a 900-page legal defense to substantiate how they really did consider every important, meaningful objection and considered it before ultimately either acquiescing or disagreeing and moving forward with their justification as to why they moved forward. So it's like, to be fair, it was one of the biggest jokes to me that came out about just the outcome itself. All these organizations that were threatening to put a legal challenge to the Department of Labor fiduciary rule, the DOL comes out with a 100-page rule and 900 pages of justification for it. And then the anti-fiduciary groups immediately leapt on that and said, see, this is bad government regulation. It's 1,000 pages. It's like, well, no, it's not. It's like 100 pages and 900 pages of preemptive defense to you knuckleheads trying to defeat it. So, welcome to how the sausage is made. But if this goes to the courts, the courts kind of get it. They understand what's actually ruling and what's explanatory. And at least the initial take I've had, and from my hearing from some of the channels I listened to, is the Department of Labor was pretty savvy about how they did this to kind of preempt a lot of the legal challenges that were threatened. They acquiesced on some of the technical terms, and we'll talk about a few of those as we go. And beyond that, they also just relented on the timeline. They extended the implementation date and kind of gave a transition period. And so lots of things that they did that will just further strengthen the kind of the validity of the deal and probably reduce its risk of being overturned.
It is kind of amusing that the saber rattling that has been going on for really less, how long? Couple of years now from Wall Street and your big broker dealers, it probably put this rule in a position that it actually could go ahead and go into effect instead of just getting put on hold while all the court cases got heard. So they maybe should have waited a little while. But I guess let's just give a quick recap of how did we get to this point, because most advisors, I think at this point, know the difference between suitability and fiduciary, and that we've been kind of living in this world of some firms were fiduciary, some firms lived under suitability, some firms and literally some advisors wore both hats for the same client, and they could take off the fiduciary hat, put on the suitability hat. I used to joke that we literally need physical hats to give advisors that says suitability fiduciary, because that would,
there are broker-dealers that have done that training by literally having two hats and teaching people to take one off and put the other one off. Got to be a couple of listeners here who work at broker-dealers who actually have been in those training sessions where you literally take one hat off and put the other one on to illustrate the point.
And it's amazing. As someone who has lived in the fee-only world my entire career, I have never sold any products. I have been under a fee-only fiduciary standard forever. It's fascinating to me that these conversations even happen, because I've never had one. I've never had the thought of is this a fiduciary or suitability conversation? And I think that there are probably a lot of listeners on that boat, but I think there's a lot of listeners out there that have lived under the suitability standard that are now saying what in the world just happened? And truth be told, a lot of the broker dealers are probably scaring their members, I would say, and maybe overstating implications.
And we can touch on a little of that. So I find it to explain the context and where we are, I kind of have to do a little bit of backstory, maybe just history for the industry that some folks aren't aware of just the origins of kind of our separate channels. So much of our legal framework today, FINRA, the SEC, Registered Investment Advisors, broker-dealers, all of that, all of the current regulatory structure basically comes from the aftermath of when the great market crash of 1929 happened. And as is pretty much true of every market cycle, you need a catastrophic bear market before everybody sees where all the skeletons are buried. And so by the mid-1930s, we realized, in addition to just some mistakes around monetary policy that exacerbated the Great Depression, we realized that we had kind of failed on some regulation of markets in the late 1920s that contributed to both the buildup and the crash that followed. And so from the early 1930s through 1940, we put in a series of major pieces of legislation out of Congress that established the actual Securities and Exchange Commission, the SEC as it exists today, that created much of the structure for the registration of broker-dealers and created this thing called Registered Investment Advisors in the Investment Advisors Act of 1940. And so kind of coming out of the 1930s and into the 1940s, we basically made two separate channels. The first was what were called brokers, stockbrokers. They worked for broker-dealers. Back then, the primary function of a broker-dealer really was to take securities into their inventory and sell them to the public. So in the most basic manner of how capital formation operates in this country, you're a big company like GE, you want to raise $100 million in a bond issuance. You don't know investors who want to buy $100 million worth of your stuff. So you go to an investment bank that facilitates the deal. They work with broker dealers who buy your $100 million worth of bonds into their inventory as dealers, and then they resell those bonds to the public, to investors, and try to earn a markup in the process. So as GE, you raise your $100 million through the broker dealer firms, and then the broker dealers make their money back plus a little bit of margin and profit by reselling the bonds to the public. And that was actually the original capital formation function of broker dealers. You're raising money with the stock issuance. You're raising money with the bond issuance. You don't know, tens of millions of people to buy your stocks and bonds because you're just a company that's out there that makes widgets. The broker dealer was a key portion of the middleman process the intermediary process that would say, we'll buy the inventory from an investment bank, or we'll buy out the investment banks that's facilitating this deal. We'll take the stocks and bonds into inventory. We'll sell them to the public. And that was how capital formation occurred. And the people who facilitated the sale of those stocks from the broker dealer's inventory were stockbrokers. And that's where they originated. Now, at the same time, there was a group even back then who we recognized were completely different. They did not, sell stocks from the inventory of their companies and broker securities transactions. They were in the business of giving investment advice. They would manage pension funds, institutional funds. They might manage money for extremely affluent individuals. They gave ongoing, continuous investment advice and were paid an ongoing fee for that service, i.e. an AUM fee. And so we separated these out and we said, brokers that work for broker dealers are registered as such and are subject to the standards that apply to what functionally is a salesperson whose job is to sell the stocks and bonds in their company's inventory. And we separated that out from investment advisors who gave ongoing investment advice and who we ultimately, with some subsequent court cases, affirmed should have a fiduciary duty to their clients. It's technically not written in the regulations that they're fiduciaries. It came from court interpretations about how an investment advisor would have to be acting to meet their investment advisory duties and not be misleading or fraudulent to the public. So we had these two channels: broker dealers that sold stocks and bonds, investment advisors that gave ongoing advice. And the Authority Act was actually very clear in saying, if you start giving advice, you have to actually register as an investment advisor. You can only avoid registration if your advice is, quote, solely incidental to the sale of your brokerage products. So, if you went out and said, buy my stock, it's a good deal for you and it'll help you retire, that was kind of considered solely incidental advice to the offering of your brokerage services. But if you gave real advice, you were supposed to go over to the other side of the line. So we had these two separate channels, and that worked well and good for quite a few decades until over the past 20 years, as discount brokerage and then online brokerage has just completely eroded and evaporated the world of the stockbroker, right? Like no one calls a human stockbroker to say, buy me 27 shares of GE at this point. We're past that point. Technology eroded that out of existence. So stockbrokers evolved for a while. They started selling other securities related products. So we saw the rise of mutual funds, third-party securities products that were distributed through broker dealers. We had the rise of independent broker dealers, because the whole point of why they were independent is that they weren't actually selling their own inventory anymore. They were just third-party intermediaries for other companies like mutual fund asset managers that wanted to sell their securities through the independent broker dealer to reach the public. So as all this pressure came on products, and people shifted more towards advice, we've had this great convergence where brokers are increasingly giving advice. They, long ago started putting financial advisor on their business card instead of stockbroker. We still had this group called investment advisors, but they were subject to different standards. Brokers were still fundamentally, legally salespeople and had a standard that's appropriate for salespeople, which is sell things that are suitable to the person you're selling them to. And then we had investment advisors who were subject to the normal standard that applies for people who give advice, which is a fiduciary standard. Your advice has to be in the interests of consumers.
Now, to jump in real quick,
Sure.
You have a great metaphor that I've seen you post on Facebook before around the difference between suitability and fiduciary when it comes to a suit. So explain that, because I think that helps kind of clear it up for anybody that's not
The simple explanation is suitability means someone has to sell you a suit that fits you. Fiduciary means it has to actually look good on you. So I can sell you a horrible, ugly ass suit that no human being would want to wear in public. But as long as it suits you, it fits you, it's your size, it's a legitimate sell. And I can say, this is a great suit for you. See, it fits, even though no rational human being would want to wear it in public. Fiduciary advice means it has to be in your interests, which means I have to actually recommend you a suit that you would want to wear.
which is in conflict with the vast majority of sales in this. It's not like going to Home Depot or Lowe's and buying a lawnmower. Like, we know when we go into that situation, they're trying to sell us the most expensive lawnmower with the biggest commissions. So why is that an issue here? Like, why is this even a conversation between suitability and fiduciary?
Well, so it's become an issue here because when we dial the clock back 40 years ago, this was pretty straightforward. Investment advisors subject to fiduciary duty had investment advisor, financial advisor on their business card, and stockbroker salespeople whose job was to broker stocks wrote stockbroker on their business card. So there wasn't any ambiguity. There was no consumer confusion about who did what. What spawned all the confusion, even down to how the media has covered this entire issue, is brokers long ago started calling themselves financial advisors, giving way more advice than stuff that was just solely incidental at brokerage services, right? They get their CFPs, they write CFP on their card, they write financial advisor on their card. And then if they ever get sued, they go to the regulators and say, oh, no, my advice was solely incidental to the sale of stocks and bonds, which it clearly wasn't really,
right.
but that's the dynamic that we've gotten into. And there's a whole separate kind of regulatory battle and debate about why is it that the SEC has refused over the past 20 years to enforce this provision that's hard-coded by Congress in the Investment Advisors Act that says if your advice is ever more than solely incidental to the sale of your brokerage services, you're supposed to register as an investment advisor. So if all the brokers out there who put financial advisor on their business card and give advice as a part of their services followed that law, they would actually all be fiduciaries as RIAs under today's law, under a 76-year-old law from fact of 1940, and we wouldn't even be having this conversation. But the SEC's failure to act in this and enforce this provision of the law is part of what's kind of created this great convergence. Everybody puts financial advisor on their business card, says they're in the business of offering financial advice, but not all of them are actually regulated as advisors. A huge swath of them are still regulated as the salespeople, which they legally are.
And truth be told, it's the consumer confusion that really matters here. I mean, if we, broker dealers weren't exactly clamoring for a giant consumer awareness campaign either to say like, hey, by the way, all of these companies are under suitability rules. All these companies are under fiduciary rules. That they obviously weren't clamoring for that either. So
no, I mean, broker-dealers long ago figured out that when you hold yourself out as an advisor and give advice, people buy the product you recommend at the end of the advice. Like, it's good for business. I mean, they didn't just kind of accidentally stumble down this path. Like, they went this way because it's very effective at selling product. And of course, the fact that giving advice is effective at selling your products on which you make your money is why we long since regulate people who give advice across virtually every profession, lawyers, accountants, doctors, all of them. We institute these separations between products and advice and institute various forms of fiduciary duties because this is a fundamental conflict of every profession, right? Like, this is why doctors are not allowed to get paid by a commission by the drug companies to recommend their drugs because it's just a fundamental conflict of advice. Instead, the drugs are separate from the doctors, and the doctors have to give a Hippocratic oath to act in the interest of their patients. So, this is sort of fundamental across all professions. We have what, in essence, has come down to a massive under-enforcement issue because Congress wrote this rule that said if your advice is ever more than solely incidental to your brokerage services, you have to register as an investment advisor. The SEC has failed to enforce this. And so now we had this massive convergence, all this consumer confusion, growing awareness of the differences of standards, growing amounts of research that says people are buying inappropriate high-priced products that technically meet a suitability standard, but they only got sold because someone held out as an advisor in recommending that product, right? And we see it right down to the coverage of the rule itself, which has all this discussion of, financial advisors are ripping consumers off, and so new regulations will apply to them. It's like, well, no, technically brokers or some brokers were taking advantage of consumers. So brokers are now going to be lifted up to the standards that apply for people who actually give advice. Unfortunately,
so it was a little bit of a tangent. Yeah, a little bit of a tangent to take you on, but I think it's important there, especially for those that haven't studied the difference in suitability and fiduciary or haven't lived under both of those worlds, because I've talked to folks that have lived in the BD world their entire careers and don't understand the fiduciary world. And they say like, well, of course I do what's in my client's best interest. I mean, I'm recommending what I think is best for them, but that's not the fundamental definition of fiduciary. So, okay, so we can kind of
So we had this arc and kind of this great convergence and debate that's bounced around for 20 years about whether the SEC is going to enforce the solely incidental provision, whether the SEC needs new rules, whether they're all so close that we just need one uniform fiduciary standard that applies to all brokers and investment advisors because they've gone through this great convergence. That was a discussion in the regulatory marketplace for a while. So then, kind of slightly out of left field, we have this action from the Department of Labor, which actually goes back about 6 years ago now. They put out this first proposal for public comment that said, so Congress gives the Department of Labor the right to oversee employer retirement plans under ERISA. It's part of their scope since ERISA was put in place in the 1970s. And part of how the Department of Labor has always regulated the world of ERISA is if you're doing work with an employer retirement plan and you're actually giving them advice, you are a fiduciary and you have to operate on a fiduciary basis. And that's been ingrained into advice for employer retirement plans for decades now, similar to the standard that we have for advice in for registered investment advisors as well. So the big change that happened that started back in 2010 as the Department of Labor began to propose rules in this area and then really stepped up when they issued a new proposal back in 2015 last year, was the Department of Labor came in and said, well, we've always had jurisdiction over employer retirement plans as part of ERISA. But if you actually look at the rules and what Congress has said the Department of Labor is allowed to do, technically the Department of Labor is allowed to put forth the guidance for fiduciary rules for anybody that could have a prohibited transaction for violating the fiduciary rules. And as it turns out, there actually is a section of the tax code that says retirement accounts also have to honor fiduciary rules and have prohibited transactions for fiduciaries that do the wrong thing. Now, in the context of IRAs, most people don't function as fiduciaries historically. Arguably, the primary context originally was that basically the IRA owner has to be a fiduciary to the IRA beneficiary, which is sort of self-evident because it's your account. So, of course, you're going to act in your own interest because it's your own account and your money. But it opened the door for the Department of Labor to say, we could actually expand what already is a fiduciary duty that we apply to employer retirement plans over to IRAs. We technically have jurisdiction to do this. And that's what's kind of unleashed this whole discussion around the Department of Labor fiduciary rule, because the DOL said, we technically have the right to do this. And when they do it, as they've now done, as we'll talk about more in a moment, they regulate the account and what happens in the account. And it's very different than all the rest of our history of our regulation, where if you sell insurance, you're subject to insurance regulators. And if you sell securities products, you're subject to FINRA. And if you give investment advice, you're subject to the SEC or a state regulator. The Department of Labor has come in and said, well, our jurisdiction actually pertains to the account. So I don't care whether you're selling a stock, a bond, a mutual fund, an ETF, a managed account, a variable annuity, or an equity indexed annuity. We're applying a fiduciary duty to anything that you recommend into that IRA. And that's part of why the Department of Labor's rulemaking process has been discussed by some as kind of coming out of left field, because relative to our existing regulatory environment where we primarily regulate by what you sell or what you implement, this world where the Department of Labor figures out they can come in and try to apply regulation based on the type of account is a new thing. It cuts across existing regulatory silos in ways that realistically are going to create some challenges in the coming years. And it forces a lot of people who've never been subject to any kind of fiduciary standard to suddenly be thrust into the spotlight.
Because honestly, I can probably count the number of people in financial services that I have come across in my career that don't deal with IRAs in some way.
Right. I mean, it's a pretty wide-reaching thing. There's, I forget what the number is now, something like $7 trillion in IRAs. And of course, the biggest source of IRA dollars is big rollovers from 401ks into IRAs, which would now be a fiduciary transaction as well. So, you could basically escape everything that the DOL has done around fiduciary by just saying, I'm never going to give any more advice on anything pertaining to a retirement account. And there may actually be a couple of broker dealers that kind of seek refuge that way and say, you know what, we'll just only give advice on after-tax dollars, and then we don't have to deal with all these rules. But from a practical perspective, there's just so much money in IRAs. There's so much opportunity there. Most firms won't and can't afford to just walk away from a $7 trillion asset base. So they have to figure out how to do this and how to operate as fiduciaries.
It has always fascinated me that advisors that were giving advice on 401ks were already subject to fiduciary standards, but you could recommend that someone roll out of a 401k into an IRA to fall under suitability standards. So it was always weird that we were in that position anyway. So it's kind of nice that it is somewhat standardizing. But you just brought up a really good point that I think is important to note. And that is none of the fiduciary rules that have come out from the Department of Labor apply to taxable brokerage accounts. These are only retirement accounts.
And, frankly, this will be the next kind of weird thing, so I mean, we talked about the two hat standard. You could be like a fiduciary for a while and then take off your hat and be subject to suitability standard. We actually still have a version of a two hat standard now. I'm a fiduciary for your IRA and I'm suitability for your brokerage account. I don't think that's a tenable disparity. It's not going to take long for the media to start picking up
Figure that out.
Why do advisors who give advice on retirement accounts held to a higher standard than the rest of your money? So I actually think this is what will probably compel the SEC to step up and act and finally do something about their own fiduciary issues. It'll take a couple of years. We might not see that until 2019 or 2020 or something, that the SEC actually gets a new rule out. But just it's not sustainable to say a broker has two different legal standards depending on whether they're giving you advice about your IRA or your brokerage account. That's not going to fly for very long.
And now, to be fair, some of the pro-fiduciary advocates were complaining about this, but based on your explanation just a few minutes ago, the Department of Labor didn't even have the right to regulate the brokerage accounts.
No, DOL had no right to regulate the brokerage accounts. Some have argued it was even a stretch for them to try to regulate the IRAs. Technically, they did have rights. They did have the right to put forth rules around how, the fiduciary rules that apply to IRAs. But even there, the DOL was actually very creative about how they did this, because technically what the rules say is the DOL basically, a little oversimplified, the DOL can specify rules about how fiduciaries work with IRAs, but the DOL doesn't actually have the legal ability to enforce against them, because prohibited transactions and improper fiduciary actions with IRAs is technically up to the IRS to enforce, not the Department of Labor. And of course, the IRS is already tapped and under-resourced, so they're not about to suddenly weigh in on the fiduciary fight about the advice that's going on inside of IRA accounts. And so the end run that the Department of Labor did, which is kind of a good segue to sort of this new world that we have to deal with. Here's basically how the Department of Labor did it. And, this is a bit kind of wonkish for people who like legal policy, but it was actually very creative of them. So what the Department of Labor said is, look, here's the basic rule we're going to specify. If you are giving advice to an IRA, whether you're recommending investments in it that are going to be income to you, whether you're recommending a rollover to an IRA, which you're going to benefit from because you're going to get assets under management you didn't have before, anything where you as an advisor are going to profit by getting someone into an IRA that you manage or sell stuff into, we're going to prohibit all of that. You are not allowed to do anything that as an advisor that you will make money off of this transaction, because anything you make money off of, you have a fundamental conflict of interest in your advice. However, there's an exception to this. And the exception to this prohibition that would basically render any advisor incapable of giving any advice about any IRA whatsoever, the exception is if you sign a contract with your clients that says, I will act in their best interests, you get an exemption from this prohibition and you're now allowed to do business. So what that means in essence is the Department of Labor basically said every way that an advisor realistically would ever work with an IRA is prohibited, because they have the legal authority to dictate, to set the prohibitions. But you can have an exemption for this if you sign a best interest contract with your clients, which effectively means everybody who does business with an IRA is now going to get forced to sign a best interest contract with the client. And the reason why the Department of Labor did that is because the DOL can't actually enforce against you if you fail to give proper fiduciary advice to an IRA. However, if you sign a fiduciary contract with your client, it doesn't matter whether the DOL can enforce anymore, because if you breach that contract, the client can sue you directly. And so this was kind of both the ingenious mechanism and the somewhat messy mechanism that the Department of Labor created. Is, in essence, they said basically all advice from an advisor to an IRA is prohibited because it's a conflict of interest unless you sign a best interest contract. Therefore, all advisors will be required to sign a best interest contract. And now we can ensure all of you will be subject to fiduciary duty with legal accountability, not because the DOL is going to enforce it against you, but because you have to open yourself up to your client suing you so that the client will have kind of a normal legal remedy.
It's brilliant legal maneuvering. And I just imagine that there's some intern that was working at the Department of Labor, that they were fighting over how they're going to do this. And there's some intern that was like, hey, what if we did it this way? And they probably got mocked out of the room, and then someone else ran with that idea. Like, that's just what I have in my head, because that's
it's a creative thing. Like, how do we regulate fiduciary for an account that we are not actually allowed to enforce over? We only set the rules around it. To have this like brilliant idea to say, well, we can't enforce the rules that we create, but we could create rules that require people to sign legal contracts and then let the courts sort it out.
And in many ways,
and that's basically what the DOL did.
That's what we've done at XY Planning Network, right? In many ways, I mean, only power we really have is to kick a member out of the XY Planning Network. We don't have any legal remedy. And yet, basically, what we did was we had our members sign the fiduciary agreement so that a client can take them to court for not following through with that contract. I mean, in many ways, it's a more creative way than that. But at its essence, that's what we've done, because, again, there's no legal remedy.
So this term that you're going to hear, well, for a long time to come, because it's kind of our new legal reality, is so the fact that you can sign a contract with your clients to say you're a fiduciary in order to be allowed to do business with their IRA is called the best interest contract exemption. Like, literally, it's an exemption from being prohibited by signing a best interest contract. So you may hear this called BICE, B-I-C-E, the best interest contract exemption. Then the document that actually gets signed with the client is called the best interest contract. So you may hear that called the BIC, B-I-C. So we're not talking about the pen. We're talking about the...
that's going to be confusing.
Yeah, it's going to be confusing for people. We're talking about the best interest contract. And basically what it says, it'll have a couple of... both the contract and kind of the related exemption have a series of sort of 5 core requirements. Number 1 is you have to acknowledge to your client that you are operating in a fiduciary capacity with respect to any advice you give to their retirement account. So all of the lawsuits that have been out there over the years where client gets sued, says, I was acting on the advice of my broker goes to arbitration panel, says, oh no, I'm just a broker that sells things. My advice was only incidental. I'm not a fiduciary. And sadly, the arbitration panel often would buy that. That's off the table, right? When you actually sign an agreement with your client that says, I'm acting in a fiduciary capacity, there's no more, oh, I was just a salesperson defense. And again, that was a deliberate. This is another brilliant thing of the Department of Labor putting this in here. You have to acknowledge fiduciary status. So there's no more an I was only a salesperson defense unless you really, truly did not give any advice recommendations. The second requirement is that you have to adhere to what are called impartial conduct standards. Impartial conduct standards basically has 3 kind of prongs to it. You have to give advice that's in your client's best interest. You have to charge no more than reasonable compensation. And you can't make any misleading statements about your conflicts of interest or compensation or any other relevant facts and materials. So
this screams reasonable compensation. So what is the definition here?
Well, so there's actually 2 pieces that get debatable here. What is reasonable compensation and what is client's best interest, right? Because I can take best interest to a very logical extreme, like until I've done 172,000 hours of due diligence to find every possible investment on the face of the planet to prove that the one I'm recommending is the best. Like, how far are we supposed to go down this rabbit hole? So both of these tests, what constitutes best interest and what constitutes reasonable compensation, essentially are peer review, professional peer-based determinations. So reasonable compensation doesn't mean you charge the lowest possible fee. Reasonable compensation means what you charge is reasonable for the services you rendered compared to the price in the marketplace. And I find kind of the easiest way to view that from the flip side is you fail reasonable compensation if you charge excessively for the services you're providing. Now, that's still a very subjective test. And so on the one hand, that's kind of the point of fiduciary standards. It's a regulation based on principles, not hard and fast rules, right? Because if we wrote a rule that said reasonable compensation is that you charge 2% and no more, well, guess what? Everybody's going to charge 1.99 for the foreseeable future. So the whole point of reasonable compensation, it's actually a longstanding legal standard in the fiduciary world. It's been tested rigorously for decades under ERISA. So this isn't actually a new thing for fiduciary regulation at all. It's a very normal thing in fiduciary regulation, just new to our world. It essentially says whatever services you provide, your cost should be reasonable to other people that provide other services. And of course, how do you defend that? You get sued, you're in a court of law, you're going to have to be able to trot out other comparable peers who charge comparably. So what it does is it kind of drives people towards similar price points for similar services. Now, it doesn't necessarily mean everyone has to charge the same. One of the great fiduciary experts out there is Fred Reich, and Fred was speaking recently at the FI 360 conference, and he had what I thought was a fantastic quote about kind of assessing reasonable compensation, which is you can charge Walmart's prices for Walmart service. You can charge Tiffany's prices for Tiffany's services. So we can have different price points for different tiers of services, but don't give Walmart services and charge Tiffany's prices. Then you're screwed.
And it's a really interesting conversation that I just wonder how influential this might be in the true standardization of service models across financial planning, because we may end up kind of shifting towards even more standardization and more standardized fees.
Yeah, it's going to get interesting. I mean, I think as a starting point, it's going to start accentuating benchmarking more. I mean, the easiest way to find out whether you're reasonably in line on your compensation literally is to benchmark to your peers. What do they do? What services do they provide? What do they charge? And are you charging a similar thing for the people who provide some similar services? So it doesn't necessarily homogenize the service models entirely, but it will start to homogenize the price points at various service levels, which I think ultimately is a good thing, right? So it says everything from, if you're a robo-advisor, you better not be charging 2% for what a whole bunch of other people charge 25 bips for, right? Like this spans the spectrum. If you're an advisor that's doing investment only, you better not be charging the same thing as a firm that does full comprehensive financial planning.
I think that's the interesting one right there, because there's a whole lot of advisors that have been doing comprehensive financial planning and investment management for 1% AUM. There's a whole bunch of people that have been charging more than that for just the investment management portion. Yep. So that'll be a fascinating push.
It's going to be some interesting pressure. Then the second
was two of them. So we had impartial conduct standards.
Yeah, well, so we had a reasonable compensation clause, which is basically you have to charge what your peers charge for similar service with a little bit of latitude. I mean, the history of legal infractions for reasonable comp were like people who were way off the scale. So, I wouldn't be stressed out because you charge, 1.1 and someone else charges 1. It's more like you better not be giving an investment only service and charging 2 when your competition's charging 25 bips kind of thing.
Right.
But as that evolves over time, like 10 years from now, we may scrutinize some of that a little more. The second prong of this is that you have to act in your client's best interest, which again is kind of could be this never-ending rabbit hole of, how much due diligence am I supposed to do in a world where this could never end? So technically, best interests, what it really means is you need to give prudent advice that another prudent professional would have given in a similar situation. So this very heavily gets judged off of what in essence are best practices and what people commonly recommend in a similar situation. So that's what will get driven off of best interest. Basically, it's what do a whole bunch of other fiduciaries that also didn't have a conflict of interest recommend, and would they have recommended the same thing that you did?
Okay. So, and that's going to be, it's subjective, but ultimately, again, maybe this will lead to some more standardization, which I think has already been happening in corners of the financial planning world. And now it's just going to get brought to a head in the brokerage world as well.
Well, and again, like this is, I mentioned this before, but like this is the nature of fiduciary principles-based regulation. The way you get challenged on this is you do something, a client, or more accurately, the client's lawyer, disagrees and thinks you did something wrong and takes you to court, and you have to defend yourself and your practices against your peers and demonstrate that what you were doing was within the norm of what other fiduciaries do. Now, the fact that that's the dynamic kind of changes things from the history of suitability and sales standards, right? Suitability's basic defense was, I checked all the boxes on the form in the appropriate way. I should be able to defend. The nature of fiduciary is, no, you could get dragged into court based on what your peers do, and you better do something that's similar to what other fiduciaries do. And so now the pressure is really on you to say, I can't just rely on like, I checked the boxes on the form, I should be able to defend myself. You have to err to the other extreme. Like the pressure's on you to go out of your way to make sure you're really keeping everything above water and legitimate. And that's the point, right? That's the point of creating fiduciary rules this way, is you can't just go right up to the line and then take a 0.01% step back and say you're in the clear. As long as you've got this ambiguity, the pressure is on you to really take the high ground. And that's exactly what this is designed to do.
So those were our first 2 points, and you said there were a total of 5. So
the other ones actually won't hit most advisors directly. It'll hit at the company level. So financial institutions, i.e. things like broker-dealer firms, are required to create policies and procedures that reasonably would help prevent violations of the impartial conduct standards. So this is actually an interesting one that will come up to companies like the broker-dealers, where the Department of Labor is basically saying, if you create a bunch of compensation incentives and deals that rev up all your salespeople to do horrible, bad sales practices, you can't just say, oh, well, if they get caught, it's their fault because they failed to adhere to the impartial conduct standards. The DOL is saying, no, if you fail to create that environment for them, if you don't give the appropriate policies and procedures to set them up for success, then we're holding the broker-dealer accountable. We're holding the entity accountable. So this one, although it won't hit advisors directly, this one I think is actually the most reforming for the industry, because now institutions have to live under the fear that the Department of Labor is going to come down on them if they are creating inappropriate incentives. And actually the DOL just outright said, so kind of, the part 3 is create policies and procedures to prevent violations. Part 4 is companies have to outright refrain from using incentives that would encourage advisors to act contrary to clients' best interests. And the kinds of examples they gave are like sales contests, banned. No more of that stuff. No more like sell 5 more annuities into an IRA and you get a trip to the Bahamas. That stuff just gets outright banned going forward. Bonuses for making quotas, all of those kinds of things are going to get banned. And so I think there'll be some really interesting shifts in the broker-dealer environment and even insurance company and annuity environment as they kind of assimilate these rules and figure out just how much they have to rein back the kinds of classic sales incentives that have been out there in the past. Because the whole point is you're not a salesperson anymore. You're an advisor, and you're being held to an advisor standard.
And again, I've never worked in kind of the FINRA world, but this is, there's going to be some broker-dealers that's a complete culture change. This is going to be culture shock if all of a sudden...
This is going to be culture shock. And, truly, in to the extent you can do things like regulate culture, which obviously is a really, really difficult thing. I think in essence, what the Department of Labor is trying to do here is change the regulatory environment around culture. In a world where FINRA just recently came out and said, gee, we've realized that maybe we need to look a little bit more closely at the culture of our broker-dealers. The Department of Labor has basically just come in and said, screw all y'all. We're just telling you, you got to have a different kind of culture. And here's the way that it's got to be aligned and structured. You have to create policies and procedures that give your advisors an opportunity to actually be impartial. You have to eliminate incentives that would discourage them from being impartial. And you have to openly disclose fees, compensation, and conflicts of interest and put it right out there on your website, available to clients on request, which will basically mean if you want to keep a really conflicted model, I guess you can do that, but you're going to have to give a disclosure document to the client's attorney that they will use as the roadmap to sue you.
Love it. I love it. I'm sure a lot of broker-dealers don't, but this is awesome.
No, I think a lot of broker-dealers are kind of rightly freaked out about this. This is part of the dynamic, and one of the things that drove me nuts about the discussion of kind of the potential impact of the fiduciary standard leading up to this is, broker dealers have been loudly, vehemently opposed to this. And you can kind of see why. Functionally, their entire reason for existing is they're a middleman intermediary to facilitate the sale of securities products. And their salespeople are no longer allowed to be salespeople anymore.
Yep.
Because they've been holding out as advisors. So the Department of Labor said, fine, we're going to regulate you like advisors. And that's not necessarily a bad thing for the brokers. As you noted, zillions of brokers out there have long said, I try to give advice in the interest of my clients anyways, because frankly, it's just good business to do that. And while I think there may be some of them that perhaps were selling some products that weren't really quite ideal, but they didn't even realize they were not great, maybe because their company told them it was great and they just didn't really do some of their own due diligence because they didn't really have a reason to. And now that those dynamics will change a little. I mean, I think truly most brokers out there really do try to act in the interests of their clients, notwithstanding all the grief that we give about rogue brokers doing inappropriate stuff. The industry data still suggests it's a relatively small number of brokers. Now, ironically, it's a small number of brokers who screw clients, get fired, then get hired at another broker dealer, then screw more clients, then get fired, then get hired at another broker dealer, and screw more clients. So there are some unfortunate dynamics around bad brokers being able to stick around in our industry and keep doing bad things because we're not very good at cleaning our own house. But most brokers are trying to act in their client's interest in the first place. So this really isn't necessarily a massive disruption to brokers. It's a massive disruption to broker dealers. And I think a lot of the dialogue that you heard leading up to the DOL rule, there was a lot of discussion of, the brokerage community in the aggregate is really opposed to the rule. But what we really find when we drill down, and I'll give a shout out to the Committee for the Fiduciary Standard, who actually surveyed brokers and said, what do you really think about this rule? Like, are you guys really that opposed to being required to act in the best interest of their clients? And the response was the majority of brokers said, I think this is a reasonable rule. Like, we're concerned about the details and the impact it's going to have on us, but we think this is a reasonable rule. The people who were freaked out were not actually brokers, except because their broker dealers told them to be scared. It was broker dealers fighting for their survival. And I do think we're going to see at a minimum a massive, massive shift in the nature of broker dealers and what they do in their business models, because they just got forced to stop being financial intermediary sales platforms. Now they actually have to be support platforms for advisors.
Well, now let's be clear, and I think you're making this point, and you're much nicer than I am, but we can call out the broker dealers and we can say, you did this to yourself because you didn't stay brokers. You wanted to get into the advisor world. You wanted to act like financial planners. You wanted to act like financial advisors and give advice underneath all of these exemptions and exceptions and all of this. You did this to yourself because eventually when you want to act like a duck and quack like a duck, eventually the DOL just said, okay, I guess you're a duck. So we're just going to call you a duck and cook you like one. And like, welcome to it.
I mean, that's... Absolutely. I mean, I would fully agree. I don't even feel bad saying about that. I mean, I think that's absolutely true. The broker-dealer community brought this on themselves. And in like the most amusing of ways, the DOL actually did include an exception in the rule that says if you actually just function as a broker order taker, you just implement the thing the client called and asked you for. You're just a stockbroker. You're not subject to the DOL rule.
I love it.
They actually wrote that exception in there. Now, of course, no broker dealer is even considering doing that because they recognize that their old sales business has been dying a long time ago and that they've been forced to shift into this advice world while they were still relying on the salesperson standard. And now that's coming to an end, or at least coming to an end for IRAs, right? So again, we'll have this weird dichotomy. Like if I'm a broker dealer, I could dodge the whole rule by just going out to all my brokers and saying, from now on, you're only allowed to deal with after-tax dollars, no more selling into any retirement accounts. And you can imagine what this is going to look like over the next couple of years. Like there's going to be some ugliness out there. There's going to be brokers that start coming out and saying, oh, no, don't invest in your IRA. You should buy this great product I've got instead because it's tax deferred or it's got tax benefits or all this other stuff. And the truth is it's probably a crappy high commission product. And the reason the broker is specifically pushing it not in an IRA is because they can't sell it in an IRA because it wouldn't meet a fiduciary standard. And I do worry that for a small subset of broker dealers, we're going to see a race to the bottom as they get all the salespeople who can't cut it as advisors to sell all the highest commission profitable products that they can only sell in brokerage accounts. And that's just part of what will ultimately bring an end to this transition, maybe another 4 or 5 years when the SEC is forced to act as well and, bring up the standards. So what you're going to see is all brokerage abuses are going to shift to brokerage accounts instead of IRAs. And that can't sustain for very long. So that'll kind of
for listeners
bring
out
the whole
there,
house of cards down.
Yeah, I mean, and we know that there's a lot that's going to change. You said it early on in the episode. We don't understand how all of these rules are going to apply and the terminology that's going to be used. I mean, there's so much that has to be fleshed out and decisions that has to be made and clarifications. And if you want, again, a over 7,000 word summary, we'll link to it in the show notes, or you can just go to Michael's blog and pull it. It was published on 4/11. But as we're kind of wrapping up this episode, because honestly, we could talk for days about this topic. Yes. And we will probably have future episodes on this. I think there are a couple questions that come to mind to me as a fee-only advisor. And the question is, well, I've already been acting as a fiduciary. I've already been doing what's in my client's best interest. Does this affect me?
Good question. So it does a little in a couple of different ways. So the first thing to be aware of is you are going to be subject in some way, shape, or form to this best interest contract exemption requirements. If you're giving advice to people and they're to roll over their IRAs, you're still going to be subject to some version of this rule. Now,
so I'm going to have to get my clients to sign one of these contracts now, correct?
So yes and no. There's actually two ways that this can get handled. Number one is you'll actually go through the best interest contract requirements. Now, so the contract portion is relatively straightforward. You can actually incorporate it into your existing advisory agreements. Broker-dealers can even put it right into their account opening agreements. So you won't even necessarily have separate paperwork for it. You'll still have the legal accountability, but you can kind of fold it into the paperwork. So you may be updating your advisory agreement over the next year. I think the bigger piece is you're just going to have to take a hard look at exactly how your business operates to make sure that you don't have things that are technically advisory conflicts of interest that could trigger additional problems or issues under the best interest contract. And even RIA fee-only fiduciaries have this because in many ways, the Department of Labor's fiduciary is actually more stringent even than RIA fiduciary. And probably the best example of this I've heard so far is if you're an advisor that, like actually many RIAs I know, has one fee schedule for stocks and then a lower fee schedule for bonds, right? Because the yields are low, so it's hard to charge the same fee. You've got two different fees depending on whether the client is a stock or a bond. And every time you rebalance from bonds back to stocks, you get paid more money because you just reallocated the client's portfolio back into the thing that pays you a higher fee. You have a conflict of interest issue.
Now, I am personally not aware of very many advisors that do that, but I have heard of that.
I've seen a number of them. So those kinds of things are going to get scrutinized. At best, you're going to need policies and procedures to demonstrate how you're not, running afoul of impartial conduct standards by how you engage in these transactions when you literally make more money by encouraging clients to buy more in stocks.
Now, to be fair, I have seen that with cash where, if you're holding $1 million in cash over here, I'm just not going to charge you on that. So that is a fair point.
Same dynamic. As soon as you recommend, if you're going to be recommending that client in and out of cash, you've got a conflict of interest as you recommend that client in and out of cash. And not that necessarily prohibits you from doing it, but it subjects you to a much higher level of scrutiny to make sure that you're really going to be able to defend that if someone challenges it in court. Now, the second way that you can manage around this, and a new term to be aware of that you're going to hear a whole lot more of going for in the future, is level fee fiduciaries. So the Department of Labor gave kind of an easy out version that said, if you are a level fee fiduciary, which means your compensation is calculated solely based on a flat fee that doesn't vary at all with the investments, i.e. like a retainer fee or a monthly retainer fee, or you're charging level fees that are based on AUM where it's the same level fee for everything. So no different tiers kind of stuff, which is one flat level fee for all AUM. You are deemed a level fee fiduciary. And if you are a level fee fiduciary, you get like a simplified, streamlined version of the requirements. You don't have to do the full best interest contract. You don't have to do the full policies and procedures thing. You don't have to do what are actually going to be some pretty in-depth disclosures that anybody subject to the best interest contract are going to have to provide. You get a very simplified version that says you still have to acknowledge your fiduciary status in writing, which can be part of your client agreement. You still have to honor the standards of impartial conduct. So reasonable compensation, best interest of the client, no misleading statements. And you have to document why the investment was a good thing to do. So you'll need a note in the client file that says like, here was our assessment of their old 401k fees, costs, services rendered. Here's our fees and costs. Here's the services we provide. Here's how we're substantiating that even though the client came to work with us and maybe even paid more than their old 401k, it was in their best interest to do so. So you'll have those three prongs, but in a relatively simplified manner. And as long as you do that, you don't have to go through all of the arduousness that's associated with kind of the full best interest contract policies, procedures, disclosures, all the rest that goes along with it. So they gave kind of the easy out. So I suspect most RIAs will either do this or quickly reform their practices so that they meet the requirements in order to do this. It's the greatly expedited version. And actually, in the long run, my gut is this may be where the whole advisory industry, or virtually the whole advisory industry, really ends out. In essence, what the Department of Labor said is, look, if you're going to do a simple AUM structure that we've long since accepted as a reasonable way to operate as a fiduciary, we'll give you a really expedited process. Just say you're operating as a fiduciary, act like a fiduciary, document what you're doing, and that's all you really got to do, which is frankly not that different than what most RIAs do today. If you want to do all the conflicted compensation stuff, what the Department of Labor basically said was, you can do that, but you have to disclose every detail of what you do. You have to have policies and procedures to demonstrate it's not creating conflicts. You have to prove that it's not creating conflicts. You have to sign a contract with your client that you won't give conflicted advice. And if you do, your client has to have the right to sue you. Even if you put them in arbitration, you have to give them the right to do a class action lawsuit against your entire firm. And so, in essence, the Department of Labor kind of said, look, y'all want to give conflicted advice and you insist that you can do it while being fiduciaries? Great. Go for it. Let me know how that goes for you in court. That's basically what they came down to.
The industry here.
Yeah. But if you want to go the simpler level fee fiduciary path, it's kind of like, hey, you can give conflicted advice and deal with all this crap, or you can have this nice, easy alternative where you just charge level fees and you get really simplified paperwork and process. And I think that's, again, in kind of this sort of ingenious nature of how the DOL structured it. Like, my gut in the long run is this is where we end up. And to me, the best comparison for it is all the rules that exist out there right now around custody and having custody of client assets. So if you ask a lot of RIAs, what they would tell you is like, oh, no, you can never have custody of client asset. That's illegal to do. And the truth is, it's not illegal at all. You can absolutely have custody of client assets. The only caveat is if you have custody, you have a new level of scrutiny, you have additional regulatory standards, you have additional compliance burdens, you have to go to additional audits, and you have to go through a whole bunch of stuff that's so arduous that the overwhelming majority of firms say, I'm just not going to touch the custody stuff, and then I get the really simple version because I use a third-party custodian. I think what the DOL is doing here is they're trying to set up the same thing, and that when we look out like 10 or 20 years from now, 98% of advisors will just all be level fee fiduciaries and operate under the simple stuff. And all the stuff we talk about with the best interest contract, the BIC, the policies, procedures, the disclosures, and all the rest of that, all the firms will just have migrated themselves away from it so that they don't have to deal with the massive compliance burdens that are actually associated with trying to give conflicted advice.
For one quick clarification, you did say that level fee means no AUM tiered schedules, correct?
No, level tiered schedules, as far as we're seeing so far, is okay. There's still some discussion about their primary concern of level fee is the fee is level regardless of what you invest them in.
Okay. Because I was curious about that, because that would be a massive change if we had to get rid of tiered AUM schedules. Almost all advisors use them.
I've seen a few people raise the question as well. I'm sure there will be more interpretations pouring over this, but the context of level fee was a level fee no matter what you recommend, not a level fee where you can only have one price point. So I don't think that's going to be an issue, but certainly stay tuned. I mean, I guess it's conceivable that could be one of those unintended consequence kinds of things, but I doubt it will be the case. It's kind of a long accepted industry practice. And frankly, there would be problems, trying to regulate no graduated fee schedule starts distorting things like your large clients are forced to disproportionately subsidize your small ones.
Sure.
Some weird stuff like that. So I don't think we'll see that as an issue. I guess stay tuned. If it turns out, if it is, I'll certainly be covering it because that would be a big deal. But the primary context of it is it doesn't matter where you put the client's money, you're getting paid the same thing. That's kind of the driving force of this.
So when does all this go into effect? How long do advisors have until they have to have all of this implemented?
You get a year. You get a year to get most of it sorted out. So kind of the core deadline is April 10th, 2017. So just about a year from now is when what they call the applicability date of when it goes into effect. This, again, was another place where the DOL was creative. So the rule is effective 60 days after it's entered in the Federal Register. So it's effective in June, but the rules are not applicable until next April. And the reason they did it that way is they had to make the rule effective while President Obama was still in office. Otherwise, the next president could come in, and if it's a Republican that's not a supporter of the rule, could quickly unwind it. Once it's effective, you can't change it unless you make a new rule. But they made a delayed applicability date, which essentially means the rule exists, but we're not going to enforce it for a year. So we're giving you all some time to get up to speed. So a year from now, you'll have to have figured out whether how you're going to follow the best interest contract exemption, whether you're going to be a level fee fiduciary. If not, you'll need to have started getting set up to meet the impartial conduct standards and give advice in the best interest of your clients. Now, there's a second transition period that says from April 10th of 2017 until the end of that year. The Department of Labor is not requiring the full extent of sign the best interest contract, have all the disclosures out. They're giving kind of an extra 8-month transition period for firms, particularly large firms, to sort out all the supporting disclosure and paperwork requirements that'll have to go with this, because it's kind of a big change to workflows and procedures. If you're a large firm that has 10,000 advisors, that all have to get up on board with this. So initial date, applicability date for the rules, April 10th of 2017, but some of the paperwork details, you get an additional transition period until January 1st of 2018.
It's certainly going to be interesting to watch. I will say that I am excited that we co-founded a fee-only network that required you to be a fiduciary.
We're certainly feeling pretty good in the XYPN network context, to say the least. We're on the right side of history here, that we basically have been running a network that already does what the Department of Labor is forcing people towards. And of course, our structure is you're a fiduciary for everything all the time, not just the IRA, right? It's
Sure.
Not just about retirement investors, but about all assets, all fiduciary, all the time. So, realistically, again, I think in a couple of years, the SEC will be forced to act, and we'll get more parity in these rules across the board. But, I wouldn't be surprised to see a lot of advisors breaking out into RIAs, coming over to XYPN network, because they'll just decide, why am I giving my broker dealer, well, I guess depending on your pay scale, 10, 20, 30, 40, 50% of my GDC to basically be a royal pain in my backside, and I don't need them. In a world where you sold products and got paid commissions, you need a broker dealer. Now, technically, the DOL is saying you could still sell products and get commissions, but you're going to be subject to a much higher standard of scrutiny over whether that was really in the best interest of your client. And with this kind of deliberately vague principle-based regulation, the broker dealer is going to likely be terrified of this and come up with very stringent requirements to make sure that they're not running afoul of the rule. And so you'll be subject to exceptionally stringent requirements so that the broker-dealer doesn't get a class action lawsuit based on what the stupidest advisor of the whole 10,000 could possibly do. And that falls on the other 9,999 good advisors as well. So, I think the broker-dealer community in particular has a lot of retooling to go through to shift from this intermediary that facilitates the sale of securities transactions for a commission into an advisor support platform, an actual advisor support platform, for which just, the groups like XYPN Network have a multi-year head start, because we were built from day one to be an advisor support platform, right? We're not in the business of being an intermediary and taking a scrape off the commissions our advisors sell products for. That's not our business. We exist as an advisor support platform. And there's a lot out there that do this in varying ways. Dynasty Financial Partners does this for $1 billion RIAs or $1 billion brokerage teams that are breaking out in RIAs. We'll do this for advisors that want to, form a fee-only practice to serve younger clients on a monthly retainer basis. So there'll be a proliferation, I think, of advisor support platforms. But it's no coincidence, I think, that most of the platforms that are doing this successfully are new startups because they don't have all the legacy of
very true
of broker dealers. Like, not even to be negative about broker dealers just to say could be negative about them, but just they have a huge challenge that, they migrated themselves towards advice and not products. Now they've come to the natural regulatory conclusion of that, which is they're going to get regulated as advice platforms, except they weren't actually positioned to be regulated as advice platforms because their whole business model still depended on getting a share of commission. And so that's going to be a tough intermediate point for most of them.
And I'll say we had this conversation 2.5 years ago when XY Planning Network was conceptualized, and that was what direction do we want to go? And we said we want to be on this side of the fence. And I will also say that we made some guesses. Those guesses have turned out correct as the direction that the Department of Labor is going. And there's a reason that podcast listeners cannot go a single episode without hearing you and I beating the niche marketing drum, because the one somewhat negative thing that I will leave listeners with is that our concern about this and a concern among kind of a subset of the pro fiduciary world has been what happens when being a fiduciary is no longer your differentiation factor. Yep. What happens when saying I'm a fiduciary doesn't mean anything because everyone's a fiduciary? How are you different? And it's why you have heard us beating the niche marketing drum, because we want you to have a differentiation factor beyond the fact that you are a fiduciary, yep. Because as of a year from now, so is everyone else that's advising on IRAs.
Yeah. And, technically, at least right now, they're only fiduciaries on IRAs, but many of them will become fiduciaries across the board because their broker dealer is not going to actually have two policies for an IRA or not, because it's a nightmare for them to manage and oversee. So they'll do uniform rules. At some point in a couple of years, the SEC will do its own conforming thing, because I think it's going to have to. It's only a matter of time. And so and a huge slew of advisors will decide, well, if I have to mostly be a fiduciary already, I'm not going to do it under this broker-dealer platform that's got all these costs for legacy things that don't matter anymore. I'm going to go out and be on my own as an RIA. And then they're really operating as an RIA fee-only fiduciary. So just, the whole industry has just gotten a massive shove towards being fiduciaries. And I think you'll see increasingly being fee-only fiduciaries, or at least the commissions may get so compressed in the coming years that even commission-based advisors are basically just getting commission trails that look like an AUM fee anyways. So if your differentiator is I'm a fee-only fiduciary that acts in my client's interests, regulators have basically begun to nuke your differentiator for the sake of helping consumers. It's a good thing.
Of course. Well, there's a reason we all wanted to be on this side of it, but on a happier note,
this is not a sustainable differentiator.
It's not. The fact that it has lasted as long as it has is amazing. But the happy note out there is for any brokers out there that are sitting in this world of what do I do in a world of compressing commissions and trying to serve smaller accounts and clients that don't necessarily have millions of dollars in assets. Can fee-only advisors really do that? That's why we got started. And so whether I can encourage you to come out to XY Planning Network 16 in San Diego down in September for our national conference, or just coming in and checking out the fee-only community in general, whether it's us or some of the other organizations that are out there, there are answers to the issues that are about to face you. So
there is life after broker-dealer. And Michael, I say that as a dude who started on the broker-dealer side.
Well, Michael, thank you for taking the time to come on and give us a synopsis of your synopsis of the Department of Labor.
Absolutely
ruling.
Happy to boil that down.
And folks, if you have questions, get into the VIP community. You can go to xyplanningnetwork.com/VIP. I am sure we will start having some discussions there if you want to ask Michael questions. Because again, there is going to be some evolution here that we're going to continue to watch. So, Michael, thanks for taking the time.
Absolutely. Thank you.
Oh, that was fun. I know it's not the best topic, not the most exciting topic in the world that you get up in the morning excited to talk about, but it's so important. And this is just going to be huge. This could completely reshape the face of financial services, and I think in a good way, but we're all going to be affected, even those of us that have been acting as fiduciaries for a very long time, and not just in the sense of we have one more form to fill out for compliance, but in the sense that everyone's starting to become fiduciaries, and we're kind of shifting in this kind of shifting world towards less commissions and more flat fees. It's going to be interesting to see how fee-only firms react and how they continue to differentiate themselves. So remember to join our VIP community to be able to ask Kitces any questions about this particular topic, interact with other listeners, previous guests on the show, as well as myself at xyplanningnetwork.com/VIP. And you can check out all the show notes at xyplanningnetwork.com/44. Thanks so much for joining me today. We'll see you next time.
You're not alone, and you're not crazy. It's scary starting, building, and growing your own financial planning firm. And that's why we put together a free private community just for you, the Cutting Edge Financial Planner. Go to xyplanningnetwork.com/VIP or text XYPN Radio to 33344 and join a network of thousands ready to change the lives of Gen X and Gen Y clients.